May it please the court. A senior lawyer here in Nashville once told me about his firm's annual interviews for partner compensation. He said that partners who have had a good year come in and talk about numbers, and everyone else comes in and tells stories. Well, I'm here to talk about numbers because the Attorney General's office has had a very good 8 years. And let me give you some of them. $200 million. That is the amount of mortgage relief that Tennessee homeowners received from a settlement that I helped negotiate. $150 million. That's the amount of Medicaid fraud recoveries by an initiative that I started. $135 million. That's the amount of charitable funds recovered by an initiative I started. 2 class action lawsuits that together spanned 36 years and 4 attorneys general. That needed to stop, and we succeeded in getting the consent decrees vacated and the lawsuits dismissed last year. Those are just some of our numbers. So now let me switch gears and tell a story about where the office has been over the past 8 years and where I would like to lead it over the next 8. When I applied for this job in 2006, I had significant litigation experience in all 3 branches of government. I had served as the governor's legal counsel. I had represented the Speaker of the House and the Speaker of the Senate. I had represented 2 Supreme Court justices. I had practiced before many state boards and commissions, and I had 19 years in private practice of handling complex litigation cases. I needed all of that because the person who is charged with representing the interest of the state of Tennessee as Attorney General is charged with that interest in every court, at trial level as well as appellate, state as well as federal. The scope and complexity of litigation in this office is breathtaking. So my broad exposure to state government and extensive litigation practice allowed me to hit the ground running. Hardly a day has gone by over the past 8 years where I did not discuss litigation strategy for a new lawsuit, review and edit a dispositive motion, or help craft a settlement proposal. But the volume of cases in this office is too great to be involved in all of them. So in addition to directing significant litigation, the Attorney General must step back, look down the road, and move the office in a direction that addresses not just today's litigation challenges, but also those that will arise down the road. And so that's why I created a new division, the Medicaid Fraud and Integrity Division, to lead the state's lawsuits against Medicaid provider fraud. TennCare is almost 1/3 of the state's budget. We need to be proactive in protecting its integrity, and I think we are succeeding. During my first fiscal year in office, we recovered less than $2 million in that initiative. Since then, we have averaged over $20 million a year. Now, that's why I created a new division, the Public Interest Division, to oversee nonprofits and charities. The nonprofit sector is a surprisingly large part of the state's economy. In the Nashville area, it represents some 15% of employment. Now, nonprofits are not regulated by the market, so the legislature has given this office the statutory duty to police them. And that is the goal of this division, and I think we're succeeding. The office successfully pursued nonprofit entities that we alleged were misused by related for-profit corporations. And we initiated a new partnership with the Secretary of State to cross-check nonprofit filings. Last year, that initiative alerted us to 166 transactions that otherwise would not have been reviewed for compliance. Now, that is why when the state entered the Great Recession, I told the Consumer Protection Team to focus on the consumer challenges that unemployed Tennesseans would face. We shut down foreclosure rescues, home foreclosure rescue scams, and peddlers of fake health insurance policies. We joined the executive committee of a 50-state effort against mortgage servicing abuses, and I participated in settlement negotiations with the 5 largest U.S. banks that brought significant relief to Tennessee homeowners. And that is why, as our soldiers at Fort Campbell have faced repeated tours in foreign countries, our Consumer Protection Team has been in court here in Tennessee on their behalf and is helping to train the financial counselors on the base. These servicemen and women are risking their lives abroad to protect us. The least we can do is protect them from consumer fraud at home. Now, that's why we've been aggressive in attacking consent decrees and class actions that for decades have tied the hands of the state in running state government. The state has been too compliant in the past in agreeing to these federal orders, and that has changed over the past 8 years. Now, some of my other initiatives are more recent. Building on the success of the Medicaid Fraud and Integrity Division, I've created a non-Medicaid false claims team to pursue fraud and abuse in the rest of state government. We've recently put more resources into the Law Enforcement and Special Prosecutions Division. Our goal is to facilitate the investigation and prosecution of white-collar crimes. These cases are different than other criminal prosecutions that require special resources and expertise. So with these changes, I think we are now in a better position to assist district attorneys general across the state to pursue these cases. Now, these and other measures to make the office more efficient and effective have been accomplished during a challenging budgetary environment, although I don't need to tell this court about those challenges. But through prudent cuts and reorganization, we have managed to achieve our successes with limited resources, and we have consistently returned more money to the general fund than we take from it. Now, when I applied for this job 8 years ago, I told the court that I had the skills and experience needed to fill the role. And after 8 years on the job, those skills and experience have only been enhanced, and the results speak for themselves. A lot depends on this office. Executive departments and agencies call us every day for advice. Members of the General Assembly submit 75% of our opinion requests. And we don't get the easy questions. We get the challenging ones, the ones that raise difficult legal questions on contested issues. This court, calls our opinions persuasive authority. When we take a position, it carries significant weight. That is because judges, state officials, and citizens know that when we issue an opinion, make an argument, or file a complaint, it is based on thorough research and painstaking analysis. Just as importantly, they know that it represents our best, independent, objective conclusions, unaffected by partisan concerns. Our reputation is our stock in trade. That's why the nonpartisan nature of this office is so important, and that's why I have zealously defended its independence. We do not represent the interest of one branch over another or one political party over another. Everyone, including this court, has viewed and should view the Attorney General as an honest broker. Now, the attacks on 3 justices this summer for somehow supporting Obamacare were particularly pernicious. This court has no control over the office once the Attorney General has been appointed. We make our own litigation decisions. We were pushed by both sides in the Affordable Care Act litigation to join their position. We said no to both sides. It would not have been a wise use of state money. It would have had no impact on the litigation. Its only purpose would have been to make a partisan political statement on a divisive national issue. And that would have weakened, not strengthened, this office. And the citizens of this state agreed. By their overwhelming vote in August, they clearly said that they want independence, not partisanship, in the judicial branch, including the office of the Attorney General. This office is one of a kind. It is appointed by this court, not by the legislature, not by the governor, not by popular vote. That gives it a unique strength, which is also its limitation. That strength and that limitation is that the office can and should be independent of partisan politics. The Attorney General has no policy mandate that comes from electoral victory. Our job is to defend the actions of the state where they can be defended and to carry out the directives given to our office by our Constitution, common law, and statutes. Now, I expect from my lawyers and staff the same that I expect from myself: excellent legal work, the highest ethical standards, and a clear separation of professional duty from personal opinion. That is how I've run the office over the past 8 years and how I would run it for the next 8 if the court gives me that honor. Thank you.